So if we wanted to look into the sources of divergence in merger control, as a collective effort, I guess we would come up with the following headings. We would say the legal systems might be quite different. We would say enforcement priorities may be different. Market dynamics might be different. Or the market test results might be different. Now, market dynamics and market test results normally should go hand in hand, but knowing what we know, what we all know, that may not be the case in different jurisdictions. So we'll need to separate those as well. Which of these sources of divergence are healthy would be the first question. At least healthy in the sense that we're sober about them and there's some predictability about them. If it is about the market dynamics, it is healthy. Someone in the relevant jurisdiction should be able to foresee that there's going to be a different outcome in that particular place. If it is about enforcement priorities, it may be still protecting predictability, the legal certainty bit. If it is a matter of legal systems per se, that actually leads into not so much the precedent body signaling that there's going to be an issue, but it's a sudden surprise sucker punching kind of a matter. Now, if that is the case, then obviously that's going to make a big sound, as you know, we have seen and heard in certain cases. Because it makes a big sound, we may be left with an impression that there's huge divergence. But when you compare statistics, basically you may come up with the conclusion that it's not that bad. There are so many decisions that go hand in hand that there will be these quote-unquote flukes. I would like to discuss if we are able to look at it that way, if we should be looking at it that way, or if we should say, yeah, okay, it's a handful, but it hurts so much, and it creates so much of ripple effect that we're still going to treat this as divergence. So taking one step back, I'd like to invite all of you to think about how many divergence cases can you think of for the last 3 years? Last 3 years for mental impression would be after COVID times, right? You wouldn't be able to give 10. If I were to count for you, and anyone raise a hand if you have something in mind that should make it to the list that I'm not listing, I'd give you Booking Itraveli, Facebook Customer, Broadcom VMware, Konecranes Cargotec, Microsoft Activision, Meta Giphy maybe, S&P IHS. While it was all conditional clearances, the conditions were so different from each other that they felt like different transactions in each country. So I won't put them under, oh, conditional clearances everywhere, but I will put them under divergence. So 7. 3 years, so many files, and only 7 cases. I honestly, not to, as a rhetoric question, but I would like to ask if anyone has anything to add to this list. If not, let's give the benefit of the doubt and add 1, so 8, right? It doesn't feel like the end of the world from one perspective. But from another perspective, if you were to talk to a child who says, every week, once, my mom and dad in front of me won't agree about something, I would say, can't I go to bed at 10 o'clock now? And my dad would say, yeah, you're old enough. And my mom would say, what are you talking about? You should hit the sack by 9:30. Every week, one as severe as life and death for a child as this, right? And every week, mom and dad would be taking hundreds of decisions. That would still feel a lot to the child, and that would still have an impact of destabilization. So I would submit that statistics won't work in this particular area, and we will have to, unfortunately, call it divergence, because these are big transactions and the impacts are big, and we won't be able to dilute them in the locomotive of what else is happening in the other transactions. If we can agree on that, then we can revisit why this divergence is happening. I was putting them under different headings. I think they match actually what have been said. So with legal systems, kind of a divergence, I was putting Microsoft, Activision, and S&P. I was enforcement priorities, I was putting VMware. Market test results, I was putting Konecranes, Cargotec, and market dynamics, booking Itraveli. Now, booking Itraveli then should drop from the list because it's market dynamics kind of a thing. There would be believers among ourselves that actually the CMA has dropped the ball on that one. And now they're, in hindsight, they're saying, no, we have seen what this was going to come down to, and we believe, it's a different market, ours. But when you read the decision and when you look at the effort that was spent by the CMA, you're left with the feeling that the theory of harm was available to the CMA. They looked into it. It's just odd for all of us that there's a 1 year, full 1 year, between it hitting the wall entirely. I mean, other than Illumina Grail, we've never seen it hitting the rejection wall entirely for quite some time now, and it getting a clearance in the UK. So it is odd in one way, but there are reasons why this may be different. Also, personal note, the approach on booking Itraveli is novel in and of itself in the EU as well, because this is not being presented as a foreclosure case to us. Now there's a press release, we don't know enough about it, but all the reading and work that you do on it suggests that this is going to come out as a quintessential strengthening of a dominant position in the hotels OTA market by way of acquiring the flight OTA capability. If that is the case, then we're losing a tad of direction in terms of, so what is it that makes you strengthen your dominant position, and on top of that, lessen competition? Isn't it foreclosure if there's no foreclosure in the other markets? So what are we talking about? But as Etienne also discussed, there could be ways of putting forward that kind of horizontal effects, and it's not my duty to go into the substance of that specific case, but we're marking it as, on the substance, there are different approaches in these two markets, in these two jurisdictions, sorry. So if I were to then proceed into another topic that I wanted to cover, which was covered at the end of the previous panel as well, but we didn't have much time to discuss that, the issue of remedy design. There, the potential for divergence seems to be even larger. And also the feeling for someone like me, who is both a practitioner, I'm a practitioner in Turkey, and also an academic, is that there isn't that much of innovation going on in the remedy design. There is quite a bit of new approach in remedies market testing. So our understanding collectively, both the enforcers and the practitioners, is better, especially in the digital markets, and that serves for better market testing of what remedies mean. But when it comes to actual designing of innovative remedies, remedies of the sort that we hadn't seen before, categories of approaches that weren't available before, we're not seeing that. The minute we walk into that territory, antitrust agencies at the moment are taking a step back, saying this is becoming too difficult to monitor. And this, I'm not criticizing it yet, but this is something we should collectively discuss in the future, because it may well be that as our articulation of concerns in the merger control become more innovative, our articulation of remedies may have to become more innovative meaning complex, more difficult to monitor as well. So in and of itself, it should not mean perhaps anything that a remedy that is submitted is too complex. It will be too complex because your theories of harm are really complex. So to remedy it without butchering up the whole rationale of the transaction, I'm coming up with a complex set of remedies. What does this mean for emerging markets is the last point I'd like to make, as I'm from an emerging market. And I would like to say that what this all means for emerging markets is quite scary. If the emerging markets were to jump on this bandwagon and they were to start loosening up their standards of proof because they started talking about innovation theories of harm in merger control, let's write ecosystems here and there, and then the court is going to cut us some slack. That's going to be pretty terrible for the products that are launched at a global level. There are signs of that happening at the moment, not in the merger control field, but in the enforcement side. There are jurisdictions where the antitrust authorities said the EU didn't get the Google shopping case right. I know best. Actually, it should have been even more draconian. So suddenly they went for even further requests and concessions, which is not in and of itself a bad thing. But then you need to question, are these emerging market authorities equipped with the correct understanding of engineering and economic analysis and market testing? Last sentence. You would then need to secure a neutral starting point for the emerging markets still. They should neither wait for other jurisdictions to decide, as it has happened with Microsoft Activision, for example. The minute it ran into issues, more than 10 jurisdictions around the world said, yay, I'm not sure what the big deal is, but I know that I'm not going to give a green light to this transaction just yet, so that I don't look like I have missed what the point is. And that is huge transaction costs. So all I'm saying is we shouldn't lose the governing principles and the governing understanding of theories of harm when moving into this new sphere of innovation theories of harm. And if we do, at this more complex side of enforcement, with the French authority, with the Bundeskartellamt, with the EU Commission, the DOJ, whatnot, they may afford to take their steps back and retest and do the right thing as they go along. But the ripple effects of that would actually mean for emerging markets that they're kissing goodbye some of the bright line rules of merger control analysis, and you may not regain them because they actually never had the capability of doing the economic analysis and the engineering questioning, as they're not the originating jurisdiction of this technology anyway. On the point of contagion that I made earlier in a different context, there's an interesting observation to be made here as well. So I constantly invite people to think of the impact of things on emerging markets. And the looser the nexus is in developed competition authorities merger control, the way looser it is going to be in the emerging markets, we can assume. This is happening in Turkey, my home jurisdiction at the moment. So you have to notify joint ventures if the joint venture parties with their independent operations meet the thresholds in Turkey, even if the joint venture has absolutely nothing to do with Turkey. A railroad pavement joint venture in Siberia gets notified in Turkey because the parties have separately operations in Turkey. Sugarcane energy, novel product in a part of Brazil, it gets notified in Turkey. And these do get notified because these parties to the JV are serious with their operations in Turkey. And when you question it, the response more frequently than not is, well, it has started happening everywhere in the world and all that. The next phase of it, I don't want to bore you with Turkish details, but I think it's an interesting intellectual conversation in the sense that there is this contagion, is that the Turkish authority has recently adopted exception markets, where they said these markets are so sensitive, digital definitely among them, that if the target has any users or turnover in Turkey, if the acquirer is meeting the targets, the threshold targets, it will have to be notified. So basically, Google is notifying a transaction to the Turkish Competition Authority, the only other authority being the Macedonian authority, because the app developer is in Macedonia. So Macedonia and Turkey. And it's because that Macedonian app developer happens to have 17 users in Turkey. And this is all because they don't want to be left out of the digital discussion when meta-GIFIs and whatnots of the world are happening, and the Turkish authority is not seeing any of these filed in Turkey. Booking e-Traveli, it's just, you know, up and down, written everywhere intellectually, but there's no filing in Turkey because, so long story short, this is going to lead to that kind of an impact as well, not only in the substance divergence, but also a very difficult load to bear if the governing principles of why notifications are made is not handled. And obviously, the ICN is doing its best to make sure that there's some sense in this. ICC is doing some homework as well, but I just wanted to raise that flag. In the ICN discussions and also at the ICC, so I'm the co-chair of the Merger Control Practice Group of ICC, the innovation theories of harm and convergence has become an important topic, but among family, I must say it feels like we're paying a lot of lip service to convergence, but actually there isn't anything that would allow these authorities to converge on, because they want to feel cutting edge. They want to enforce in these circumstances. It's not only about merger control at the moment. You know, all emerging market authorities are super happy to go after HR-related cartel cases too suddenly. So anything that feels like the new trend, you know, it's going to happen in the more sophisticated authorities of the emerging markets like KAJI or the Turkish authority, you know, because they have the administrative capacity and they want to come across as cutting edge as well, but that's extremely dangerous in the innovation theories of harm sphere. There's a lot of discussion, it's in the agenda, but ultimately I don't think there's a tool yet to make sure that there's actually some cause for concern that they act. Because typically what happens is if there is a cause for concern, the more developed authorities of the world already take an interest in that, and the concern is originating from their jurisdiction. And it's by way of reflection on the emerging markets anyway, so it's only for them to wait. But they want in on it. They want to do something of their own. They're confusing it a little bit, I think, with cartel enforcement kind of matters as well.
Yeah.